Mr. Attorney General, we appreciate your being here. We appreciate how you have led this department with integrity and discipline and your enormous public service. I appreciate your willingness to sit through this endless cascade of false allegations and conspiracy theories and innuendo. The chairman began this hearing with the dramatic statement that justice is no longer blind. By that, he means that justice is no longer objective or impartial, that it is suddenly now a respecter of persons in the wrong way. That is, it will distinguish between people based on their position. But of course, the chairman's real problem is that justice remains no respecter of persons. That you can be the former president of the United States, but if you commit crimes, you'll be held responsible. That's his problem. That's the problem of all my Republican colleagues right now, and that is they're about to nominate a convicted felon. And they don't know how to cope with that. They don't know how to cope with the justice system that, in fact, treats Donald Trump the same as it would any other citizen. And so they have to push these conspiracy theories that they know are patently false. And they try to run over you with questions they won't let you answer, because their whole arguments are utterly insupportable and destructive of our justice system. They care more about this convicted felon than they do the country. I have to say I'm pleased and a bit surprised to see that the flag in this committee is still flying right side up, because they want to turn it upside down, even as they want to turn our justice system upside down. Let me address the conspiracy theory of the day, which is somehow President Biden, through your department, has convicted Donald Trump in Manhattan in an effort to weaponize justice against the former president. So let me just ask some basic questions about this phony conspiracy theory. Did you appoint Alvin Bragg to be Manhattan DA?
No.
Of course not. He's elected. Did you select the jury in that case?
The judge selected the jury.
Well, did you select the judge in that case?
No.
No, of course not. The judge was randomly selected. Did you select the jury in that case?
No.
The jury was actually selected by Donald Trump and his attorneys. Did you reach a verdict in that case?
No.
Did you instruct the jury in that case?
No.
Did you tell the prosecutor what charges to bring in that case?
No.
This was 12 ordinary New Yorkers who weighed the evidence and found Donald Trump guilty of 34 felonies. And instead of celebrating the fact that in this country, an ordinary group of jurors, an ordinary group of 12 people can still adjudicate a case involving one of the most powerful people in the country, no, they would denigrate the whole system. They would tear it down. In the service of this convicted felon, they would tear everything down. They would tear the house of this democracy down around them. They say it's unprecedented to bring charges against a former president. You're damn right it's unprecedented. We've never had a president of the United States who was making hush money payments to a porn star and then falsifying business records to cover it up. Yeah, that's unprecedented. We've never had a president withhold classified information and then obstruct the investigation. That is unprecedented. We've never had a president incite a violent attack on the Capitol. That is unprecedented. And you know what else is unprecedented? The fact that so many leaders of that party are perfectly fine with all of that. In their headlong pursuit of power, they're perfectly fine with that. They're going to nominate a convicted felon as their presidential candidate. And they have another conspiracy theory, which is when a search was executed of the president's residence in Mar-a-Lago, they went in, as the president said, locked and loaded and ready to take him out. Yet another dangerous falsehood. And your dedicated public servants at the Justice Department are having their lives threatened because of the irresponsible actions of people on this committee and in the Senate and elsewhere who would endanger the lives of those committed to enforcing law and order, even as they claim to be a party of law and order. Mr. Attorney General, I am grateful for your service, for your withstanding all of this. We will get through this because of people like you and the and the honorable public servants at the Justice Department. Mr. Chairman, I yield
Mr.
back.
Chairman, Mr. Attorney General, the reality is Mr. Herr, Special Counsel Herr, found that then former Vice President, President Biden, had retained and disclosed classified information. Isn't that true?
Mr. Herr has presented a long report.
Isn't that true? I mean, come on. I'm practically quoting right from it. You wouldn't disagree with that
I won't disagree
assessment?
with I'm not going to comment on his report. He sets forth, I appointed him to investigate
Right,
the allegations about classified documents.
So the reason that we end up talking over you is because a simple question like that goes unanswered. You're non-responsive. You're non-responsive to the question. Because that is what Mr. Herr found. And then he also found, and you're not going to like this because I'm going to quote from it. From this, he basically says here that he found Mr. Biden to be sympathetic and here he is, a well-meaning elderly man with a poor memory. And so he made a prosecutorial decision that he wasn't going to prosecute. Are you going to dispute that? You're not disputing that, are you?
Mr. Herr's report.
Okay, you're going to say it stands on its own. Okay, so it stands on its own. No, because you're not intent on answering. You want to be non-responsive. You want to filibuster.
I'd like to answer your question.
Do you dispute that? So let's just face it. Mr. Biden has not been prosecuted, correct?
That's correct.
And the rationale given by Mr. Herr is because he was a sympathetic, well-meaning elderly man with a poor memory, and he thought the jury would have sympathy towards Mr. Biden.
That was one of a long list of reasons that Mr. Herr gave for his decision.
Give me one more reason.
He found that, look, I don't want to get into a discussion about this, but I will say one of them was that the president was completely cooperative in this matter.
That's the reason, huh? Okay, all right.
You asked me one of the reasons. That was one of the reasons.
The issue that we have here, you don't want to give us the audio tape. You don't want us to have the recording. But ultimately, the issue is whether the transcript actually supports the special counsel's determination. Now, your office has basically pled two things in court, claiming, number one, executive privilege, and number two, this kind of interesting novel approach saying deep fakes, AI. Right. Did they consult, did your staffer who filed that, did they consult with you about the deep fake AI rationale for not providing the audio to us?
You're mischaracterizing the filing. That was one of, again, a substantial number of arguments made in a Freedom of Information.
Did they consult with you specifically about that idea, that notion, where they were going to say something like, quote, this is from the pleading, the passage of time and advancements in audio, artificial intelligence, and deepfake technologies only amplify concerns about malicious manipulation of audio files, close quote. Did they consult with you about that provision?
I'm not going to talk about internal department deliberations. That was one of a large number of explanations in the document you're talking about.
And I'm talking specifically about that particularized rationale. And you don't want to discuss it, which is why you're non-responsive. And that's why we need the audio. Now, let me explain why. Because your attorney also said that you did alter the transcript. And they said it was filler words, repeat words, and, I. But you know what? We don't know whether they're the blank, he said there were blank times where there was silence. We don't know whether those were 1 minute long, 2 minutes long. We don't know if he sputtered for and, because those were edited out. We do not know whether this supports and substantiates Mr. Herr's findings. By the way, you want to rely on Mr. Herr, you need to go back and listen to his testimony. Mr. Herr was pretty conclusive there that he had a poor memory. He was not able to answer all the questions. Substantively, the transcript may be accurate, but you know what? The audio would tell us so much more, which is why the Supreme Court, in the case that you poo-pooed when Mr. Fitzgerald was asking about, they said, look, if there's editing that's gone on here, That's the rationale. And there was editing. Your own office admitted it. But you won't admit it today. You've been non-responsive. And that's why we need the audio. And that's why you're here. Yield back.
Gentleman yields back. The gentleman from Texas is recognized.
Thank you, Mr. Attorney General, for appearing before the Judiciary Committee. I read a report recently that the D.C. United States Attorney's Office had only devoted 5% of resources to January 6th prosecutions. But I've also understand from many conversations that the most or all of the United States U.S. Attorney districts contributed an AUSA or an investigator to the effort. Can you confirm whether the department across the board has been providing additional support from other U.S. attorneys' offices in terms of AUSAs or investigators contributing for the January 6th investigations?
Yes, that's true, and that began before I became Attorney General. That continued after I became Attorney General.
So multiple resources across the department have been devoted to that effort, including other districts?
Yes,
okay.
Because of the significance of an attack on democracy in this body.
The reason I'm asking about that is in terms of the focus of the resources of the department. If staff would put up on the screen, there's a number of people here that I want to see if you can identify who they are. What we have here in the bottom right-hand corner is a woman named Lizbeth Medina. She was found dead in a bathtub in Texas. Her mom found her, hoping to see her in a parade that night. She was killed by Rafael Gouveia Romero, who was here illegally. On the bottom left-hand corner, you have Laken Riley. She was killed by 26-year-old Jose Ibarra, arrested by U.S. Customs and Border Protection after he unlawfully entered the United States near El Paso, Texas. Up above, you have officers Richard Uruso, 26, and Officer Christopher Abreu, 26. Both were shot this last weekend by Bernardo Raul Castro Mata, a 19-year-old Venezuelan national apprehended by U.S. Border Patrol after he unlawfully entered the United States near Eagle Pass in July of 2023. What we have is a continued effort by the federal government to fail to secure the border of the United States, and Americans are dying or getting shot. In this case, law enforcement getting shot, 2 young women who are dead. My question for you with respect to the department is, do you believe that Texas has a right to defend itself and to ensure that people who are in this country are not here illegally, and that we can protect the citizens of Texas from people unlawfully here who are committing crimes to Lizbeth Medina, who's no longer with us because the federal government refused to do its job? Yet the Department of Justice is suing the state of Texas to stop implementation of SB 4. So do you say, as the Attorney General of the United States, Texas does not have a right to defend itself and to protect our citizens from murder by people who have come here illegally into the United States?
I say, as the Attorney General and as a human being, that my heart goes out to the families, that these are terrible, terrible events. And I say, secondly, as the Attorney General, the way to stop people like this from coming into the United States is to give more resources to the Border Patrol so that they can prevent
Mr. Attorney General, no.
You don't want to
we the people of Texas, money's not going to solve the problem when the Department of Homeland Security and the President of the United States refuse to enforce the law, ignore the policies, and Lizbeth Medina would be here alive today if we were following the law. Laken Riley would be here today if we had not released a killer onto the streets of the United States of America through parole policies that this administration is advancing. And the Department of Justice is suing the state of Texas in court, taking valuable resources to go against the people of Texas, when Texas simply wants to say that we should have a say in stopping people who are illegally, arrest them, and be able to deal with that on our own terms when the federal government refuses to do its job.
As reflected in our filings in that case, we are in court because the United States Supreme Court in Arizona versus the United States held that states cannot adopt their own immigration.
You're in court because you're choosing to try to stop Texas from enforcing the laws that the federal government is refusing to enforce. And by the way, that's not the same thing as Arizona. But a final question in my last minute. The Department of Justice did not assert privilege with regard to the transcript, correct?
That's right.
And you articulated a minute ago to my colleague that the best evidence rule says that the transcribed copy is admissible, right? But how can you claim privilege in the face of not just a legislative inquiry, but a constitutional impeachment inquiry? How can you claim privilege for something that you just testified was effectively the same thing? How can you claim privilege for the audio of the transcript you just testified was the same.
I just testified the words are the same. Sensing and audio is different. You have not given any explanation, and there's nothing in the impeachment resolution that would make a difference with respect
Well,
to
I respectfully
audio.
disagree. I would ask you one last question. Is the decision not to prosecute President Biden for effectively the same crime for which DOJ is prosecuting President Trump, is it because DOJ has determined the president is not mentally fit to defend himself and stand trial for his crime, but former President Trump is?
I say again, that's an inaccurate description of Mr. Herr's report, and I would rest on Mr. Herr's report.
It's the only assertion he made. I yield back.
Gentleman yields back. The committee will take a short break, and then we'll be back in 10 minutes, 5-10 minutes.
Now I want to move on to another subject. Our gentleman from Arizona on the other side of the aisle gave away the game today when he said why he wanted the audio transcript. He said, we wouldn't know if Joe Biden had said and. So I just want to ask you this question. Special Counsel Robert Hur said that this transcript was accurate. The written transcript was an accurate rendition of the audio transcript, correct? Except for some stutters.
Yes.
So what the gentleman from Arizona wants is that transcript audio with the and. Because Joe Biden stutters. He's had a stuttering problem his entire life. He overcame stuttering. He was made fun of in school, and he overcame this disability to become president of the United States, a leader of the free world. And it is despicable that my Republican colleagues want to go after him for his stuttering problem. They should apologize, and I yield back.
Gentleman yields back. The gentleman.